We go to section 168, resignation of a director. Resignation, section 168. Director may resign his office at any time. There must be notice in writing. Board is required to take note of the resignation. Acceptance of resignation is not necessary, only noting. Director must also send a copy to the ROC along with reasons. Now, I do not know what reasons will be given by a director when he doesn't want to give any reason. Most of the directors would not like to give reasons for resignation. Just one line resignation that I hereby resign. Because directorship is an act of will. Resignation is also an act of will. And I do not know why this requirement has been made. Therefore, in my opinion, no resignation letter should give reasons. Acceptance is not necessary. Board has to note. Then next board's report should mention about it. Resignation takes effect from the date on which the letter is received by the company, unless the director mentions any specific date. Otherwise, the principle is that resignation takes effect immediately on the date on which letter is received. And this is a new provision. If all directors resign, what will happen? Because it is quite likely that all directors of a company resign and there is no director. Company is left without a director. To provide a solution on that problem, this provision has been made. I think all those who are standing there, either you leave the hall or occupy your seats. Here also, those people who are standing there, that group, you tell that group also. I think इनको बोलो. You leave the hall or occupy the seats. You are disturbing others. That group standing there, those four gentlemen, either you leave the hall or come here. Because all of these people have paid money. Those girls, you come here or leave the hall. So, resignation will be taken note of by the board and included in the director's report. Copy to be sent to ROC. If all directors resign, then you can resort to this provision. Now, before I go to this removal, there was a question raised during the tea break whether, in respect of appointment of independent directors, Section 160 would be applicable. As I said, 160 is similar to 257. Notice to be given to the company for appointing a director at the AGM other than a retiring director. In my opinion, in the case of independent directors, this provision will not apply. This deposit of 1 lakh rupees and notice, because independent directors are not proposed or nominated for election at the AGM by the shareholders. That notice to be given by a member to the company is when a member proposes any person to be appointed as a director at the AGM, other than a retiring director. In the case of independent directors, since they are selected by the board and nominated indirectly, we can say nominated by the board, to be appointed at the general meeting by the shareholders. Therefore, in my view, this 160 section about that notice will not apply. Removal, 284. Any director can be removed by ordinary resolution at any time. There is no protection to any director except directors nominated by financial institutions or the government, because the respective statute contain a provision giving protection to those directors. Similarly, directors appointed by the company law board in the proceedings under section 397 or new provision will not be liable for, cannot be removed by the company. Similarly, directors appointed by the government and directors appointed by a court of law, they cannot be removed. Otherwise, any director, including executive directors, can be removed from directorship. And as you know, the well-known judgment in the Escorts Limited versus LIC, it's a classic landmark judgment in this country on this subject. The court has said that shareholders have absolute right to remove any director. No reasons are required to be given for removal. Director has no opportunity of hearing except making a representation in accordance with that section. And lastly, no judicial review will be allowed. Supreme Court has also said that under section 169 of the 1956 Act, shareholders can demand a meeting, requisition EGM, and propose a resolution to remove any director. Judicial review of removal is allowed only in the proceedings under 397 to find out whether there is operation of the minority shareholders or not. Otherwise, director cannot complain or say that I was not given an opportunity to hear. Now this section provides that there should be an opportunity of hearing. Chapter 12, Meetings of the Board. First board meeting must be held within 30 days, newly incorporated companies. Then 4 board meetings with an interval of not more than 120 days. This is a new provision. How to count 120 days? How will you count 120 days? You have to buy that book on interpretation, because there is a discussion of about 5 to 7 pages. How to count months, how to count weeks, how to count days, and how to count year. There is ample case law on everything. For example, the general rule is that in counting days, the first day is to be excluded and the last day is to be included. So when you count 30 days, the first in the series of days from the date of the event should be excluded. But I won't be able to discuss all that here. You have to spend 400 rupees and buy a book. Now that money goes to the institute, not to me. I have not charged a single pi as royalty or anything. Video conference. This is a new innovative provision and quite useful in many cases, and except those resolutions which are required to be passed at a board meeting physically as prescribed by the government, every other resolution can be passed through video conference meeting. Not only entire meeting should be held by video conference when you want to do that, but even some of the directors can participate in a video conference meeting. For example, if you have a company in India, one director is here, 3 directors are in Japan, all the 3 directors there can participate through video conference. One director can be here. If all directors participate by video conference, there will be no place of the meeting. We have that concept of place. Board meeting held on so and so at so and so. No need, because there is no place. Everything done in a video conference meeting will be as valid and effective as done at a physically held board meeting. Quorum provisions will apply. There should be a quorum and disinterested quorum. Same provisions will apply. Attendance at the board meeting through video conference will be similar to attendance at a board meeting held physically. But you need not keep attendance register. No need. Because the law requires evidence of the proceedings of video conference meeting to be preserved as evidence. The law also requires that proceedings of the meeting will be recorded in the minute book by the company secretary. I mean, not necessarily by the company secretary, but should be recorded. Those minutes will be as valid and effective as minutes of a physical meeting, will have the same evidentiary value in the court of law. If you recall sections 194, 195, which gives the minutes evidentiary value unless contrary is proved, and everything recorded in the minutes is final unless contrary is proved. So minutes is a very important document because it has a great value when it comes to producing that as evidence. And the same minutes will be recorded in the minute book. But as you know now, everything that you needed to record physically in a manual register under the 1956 Act can be done electronically. Notices can be sent electronically, board meeting notices, agenda. All statutory registers can be kept electronically. All documents can be sent by electronic means. There is no need for physical paper unless you want it to be preserved. sometimes people may think that there should be a paper in the file as evidence. That's fine, but otherwise legally it is not required. Now Rule 3 gives the detailed procedure which all company secretaries must capture and understand. Rule 4 says that only the following matters cannot be transacted through a video conference meeting. And these are the matters. That's all. Only these. Please remember, whenever in the Companies Act, the provision says that such and such decision must be taken by the board at a meeting. There are many provisions we know, like we had section 292. Now we have section 179. Following decision shall be taken by the board at a meeting. And several provisions are there scattered in the whole Companies Act, which says that such and such thing should be done by the board at a meeting. At a meeting. At a meeting will now mean meeting held physically or by video conference. And therefore, except these matters, all other resolutions can be passed in a video conference meeting. So we have now 3 ways of passing resolutions, 3 means of passing resolution. 1, physical board meeting. 2nd, circular resolution by the board, except those matters which are not allowed to be done by circular resolution. And 3rd, video conference meeting. Video conference meeting and physical board meeting are equal in all respects legally, except that this cannot be done in a video conference meeting. So this is going to be a very useful provision, particularly those companies in India which have foreign directors. And if they are at different places or even at one place, they can get connected to the Indian director, or even if there is no director in India. Suppose one person is in London, one is in New York, one is in Tokyo, all of them can get connected with each other, pass any resolution, and tell the company secretary tomorrow that record all these resolutions which are valid and effective resolutions. The only thing is that the procedural requirements regarding maintenance of documents, minutes, and preservation of the evidence proceedings in the tapes should be carefully ensured. So this is all about video conference meeting. Notice of board meeting. Now some people will ask whether in the case of video conference meeting this 7 days notice is required or not. In my opinion it is required, but it can be sent by email. You can send all notices by email now, no physical paper is required. And you can preserve email. Email can be preserved in the computer itself, or take a printout and keep it in the file, because we have that mentality of keeping everything by way of paper in the file. Of course, if you want to do that, you can definitely do that. Failure to give notice, penalty of 25,000 rupees. Of course, this will be imposed on company secretary, because it is the duty of company secretary when there is a company secretary. One person company, small company, dormant company, I think we can skip this. Quorum, 1/3 or 2, whichever is higher. I have already mentioned that quorum for the video conference meeting will be the same, and directors participating through video conference will be counted for quorum, unless they are interested directors. That rule will of course apply equally. Fraction of 1/3 to be rounded off as 1. Quorum must be disinterested directors' quorum. At least 2 directors are necessary when you have more than 2/3 of the total number of directors as interested director. For example, in a case recently in Mumbai, the company had 10 directors, 1 managing and 9 independent. I mean independent and non-executive. 9 non-executive, 1 executive. There was a resolution for approval of commission payable to non-executive directors. All 9 were interested, and there could not be a quorum because what was left was only 1. I told them, you do one thing, you pass 2 resolutions for commission approval. One resolution for 5 directors, other resolution for 4 directors. So in the first resolution, the other 4 directors will be disinterested. In the second resolution, first 5 will be disinterested, and in both, managing director will be disinterested. This is a solution. Company secretaries have to find solution and not only tell the management, ye nahi hoga. You cannot do this. I remember a story on the lighter side, because just a relief. There was a company secretary in one group where I was working, and power of attorney given to the managing director long back mentioned that one of the powers would be to appoint employees on a remuneration more than 15,000 rupees per month. So long back, 1980s. So the managing director called company secretary and asked him, I want to appoint one person in so and so position at a salary of 50,000 rupees per month. And I have already committed to him. Now, a shrewd company secretary, I mean an intelligent company secretary, would say that, yes sir, you can do it. You have the power, but there is a technical difficulty of power of attorney. I will get it amended. Instead of this guy said, no, you can't do it. So he got angry. What do you mean by I cannot do? I am the managing director of the company. I need a person at a salary of 50,000 rupees. If my power of attorney gives me power up to 15,000, you amend it. Now actually this power of attorney should be amended, should have come from the company secretary. The managing director is telling him. Fortunately, he was not fired by the company. Anyway, so we have to provide solutions, and there are legitimate solutions available by interpretation of the provision. We have to learn that. So this is the solution. This is I have included this in this presentation because I have a classic recent example of this provision. This was clause 75 of Table A. Table A of 1956. Clause 75. Continuing directors may act notwithstanding any vacancy. In this case, listed company was in deep financial trouble. Out of 8 directors, 6 resigned. Public company, only 2 left. Public company requires 3 directors minimum. The company entered into a package with a bank, revival package, OTC and further money. They passed a resolution at a board meeting with 2 directors, sent it to the bank. Bank's legal department raised an objection, saying that Companies Act requires minimum 3 directors. You have 2 directors. This resolution is not valid. It actually happened. They came to me for legal opinion. And I told them that, look, this provision has been made with the intention of allowing a company, the board of the company, to function till one more director is appointed. There will be a contravention of the section which requires minimum 3 directors. There is no doubt about that. But the resolutions passed will not be invalid. And that is why this is a provision made in 1948 in the English Companies Act, and there is ample case law also available. In the next part it says, after but it says, if and so long as their number is reduced below the quorum fixed by the Act for a meeting of the board, the continuing directors or director may act only for two purposes: to call a meeting in order to appoint a new director, or to appoint a director. So even one director can appoint another director. Suppose your company is left with only one director. He can appoint another director under this. Sometimes these occasions do arise, and I thought company secretary should be aware of it. Circular resolution, very much simplified, and I must thank MCA for this. Very simple. 289 section was a bit complicated when it came to counting the number of directors who could approve the resolution. Now it's very simple. And you can send the circular resolution by email. You can get the consent of directors by email. Preserve it. Don't bother much about signature. Somebody was asking me, when you say you can get it by email, there will be no signature of consent. I approve. I said no need, because when electronic evidence has been accepted by the court, Evidence Act has been amended in the light of Information Technology Act 2000, and now Companies Act also been amended. Evidence Act says that this type of evidence can be accepted. There is no need. Last date. For example, if you send the circular resolution to 4 directors, one director sends it back on the 1st, one on the 2nd, one on the 3rd, one on the 4th. But the requisite majority for passing the resolution is completed on the 3rd itself. Then you have to follow. No, I said the requisite majority. If the requisite majority approves it, then on the last day of the series of dates can be treated as. Unless there is some serious problem. Normally it is not. But when there is an infighting between directors, then that's a different issue. Now, please remember that this provision that it should be sent to the registered address of the directors in India has actually no meaning now. It should not have been included, but they have included it, because when you are allowed to send documents electronically, then there is no need to send by post a copy of the resolution to the address. Anyway, you can ignore it. Approval. 1/3 or more. If require this resolution to be passed at a meeting, then you cannot pass that resolution by circulation. Sometimes it may happen, directors might say that no, this matter should be discussed at the meeting, face to face, and then decided. That's fine. Resolution must be recorded in the minutes. This is company secretary's duty. Committees also can pass circular resolution. Please remember, now there are several committee requirements under the new Companies Act for listed as well as unlisted company. This committee, that committee. At least 3 committees are mandatory. Then you have CSR committee. All these committees can pass all resolutions by circulation, circular resolution, except when the statutory provision says that it should be passed at a meeting. For example, issue of duplicate certificate. Now the new rules imply that every matter of issue of duplicate certificate must be approved by the board. Under the 1960 rules, issue of share certificate rules, the board or a committee consisting of particular number of directors was allowed to do this. Now it is not allowed, only board. But the board can pass resolution to issue duplicate certificate by circular resolution. So these aspects have to be, because now there is a time limit for issuing duplicate certificate. And stock exchanges have already laid down time limit in the case of listed companies. So you have to ensure that you do it within a particular time. Now, unfortunately, the delegation of power for issue of certificate is not expressly allowed. And the rule says it should be approved by the board. And the rule of interpretation says that unless expressly allowed for delegation, power cannot be delegated. So that problem is there. But circular resolution, in fact, I am of the opinion, I have advised some of my clients that for a limited purpose, you can delegate the power to company secretary or a committee. For example, you can delegate the power to company secretary to examine the case, find out whether all the documents have been received for issue of duplicate certificate, indemnity bond, etc. And the case deserves to be decided by the board in favor of the person to issue the certificate. Then company secretary will give his report to the board, which can be done electronically by email. And board will pass a circular resolution to issue. So it is quite possible, not at all difficult. No, but when the statutory provision, for example, we had section 292, similar 179. It contained 5 matters, and out of 5, 3 matters could be delegated, because there was an express provision for delegation, like giving loans, borrowings, or investments, etc. Other 2 matters were not allowed to be delegated, like issue of debentures. And therefore, the interpretation was that you cannot delegate it because the statutory provision allows you to delegate only some out of all. So this problem is there, but in my view, limited delegation for issue of duplicate is possible. Committees? Sorry? Yeah, of course. I respect that. Following companies must have audit committee, nomination and remuneration committee of the board, I think we can skip this. There is nothing much different from the old law.
What about the second part? Ability to read and understand.
But this was there earlier also.
I know, but with all the ability to read and understand.
Yeah, but one can say that, yes, I have an ability to read and understand. All these matters relating to audit committee, company secretary will have to deal with, because company secretary is the secretary to the committee. So naturally you will have to deal with all these. Nomination and remuneration committee. Lot of people are struggling for creation of nomination policy, succession plan. Now new clause 49 requires succession policy. This requires nomination policy. This also requires people at certain level to be appointed through this committee, selection of those people. But my interpretation about that is that only when somebody you want to select and appoint to be subsequently elevated to the position of directors, because they are using the word eligible to become directors. And directors obviously means executive directors, not non-executive directors. So only when you want to select a person at a junior level, I mean senior level but junior to managing or whole-time director, subsequently you want to promote him to executive directorship. Only those cases this committee should consider. Not all appointments of senior level employees. Yeah, but see the wording of that. I know there is an explanation also. See the wording of that section. How would you interpret this? See what it says is that the nomination and remuneration committee shall identify persons who are qualified to become directors. What does this mean? Qualified word certainly not in the context of educational qualification. It is a comprehensive word. Qualities, I would say qualities. Qualities of a person who would become subsequently an executive director. So, who are qualified to become directors and who may be appointed in a senior position. May be appointed. So, my interpretation is that when you are looking for a person who would be initially taken at a senior level of management below the board, and then that person would be elevated. He may or may not be elevated subsequently, that's a different issue. We are not concerned with that. That is the management's decision. But if the management says that we are looking for a person who would take charge of executive directors, that position only should be considered by this committee. Otherwise, these words, who are qualified to become directors and who may be appointed in senior management, would become redundant. And one of the rules of interpretation is that you cannot add or deduct words, nor can you change the words, or read a provision in such a way that it is rendered redundant. So considering all this, my interpretation is this. Powers of the board. I don't think there is much to discuss about this because this is similar to 292, except that 292 contained only 5 matters. Now this has about 15 matters. All these resolutions must be passed only at a board meeting. No circular resolution is allowed. Of course, board meeting including video conference meeting. In certain cases, delegation is expressly permitted, like loans, guarantees and securities. These are more matters. So there is a lot of work for company secretaries. I don't know why people are still complaining. Yeah, there is a long list. Yeah, you have to call emergency meeting. These are additional matters prescribed in the rules. Company secretaries must know that all these things will have to be done by the board at a board meeting, not by circular resolution. There are so many things. And other than this, we also have a few matters under clause 49. Where there is a delegation allowed, you must advise the management that this power can be delegated so that it can be done faster. Decision can be taken faster. You cannot wait for the next board meeting. And many companies have done that. In fact, I have seen a company, large company in Mumbai, has delegated power of borrowing up to 10,000 crore rupees to a committee. Because there is no limit. Shareholders approval, this is equal to 293. Section 293. Only two are important for day-to-day purposes. One is this, to sell, lease, or that also very rarely, of course, once in lifetime probably. Only borrowing. The only difference is that under 293 ordinary resolution was sufficient. Now it is a special resolution. Then we also have now the definition of undertaking. There was no definition, so we had to rely upon definitions given in other laws and case law. There is a lot of case law available, of course, but now they have tried to limit it to only a particular size of the undertaking, requiring shareholders' approval. Otherwise, board can do it. There is some problem in the calculation, but I think that will get settled. Contribution to charitable funds, donations. This is in addition to CSR. And I think all of you are aware that CSR is not mandatory. CSR is optional. (135) section doesn't make CSR mandatory. If you read subsection 5, it says company must spend 2% of net profit. If you go down, proviso, how to interpret provisos is a big difficulty. You can get it in that book. I am not marketing the book. And even if I do, that is not for my benefit. So, proviso, one of the provisos below subsection 5 says, if a company does not spend up to 2%, it shall give an explanation in the director's report. So, reading substantive provision and the proviso together, the interpretation is that CSR is not mandatory. Huh? Yeah, but again, somebody can also take a view. No, listen. Somebody can take a view that if I do not want to contribute at all, and I am ready to give explanation in the director's report, why I am not spending, then what is the need for a committee? Then harmonious construction rule can be applied. This is also discussed at length in that book. Okay. Political contributions. Yeah, it will be valid. Yes, absolutely valid. All earlier resolutions passed, even in respect of borrowings, for example, 293 1A, 1D, they will be valid. Yeah, but that 1 year is not in the statute. It is in the circular. Circular has no legal sanctity. Anyway, but many companies will get a new resolution passed because you can pass it by postal ballot also or at the AGM. And it's a very simple resolution. We have been passing repeatedly. 293 1D resolution. It's not a big thing. Because there is no limit. In addition to paid up capital and free reserve, you can authorize the board to any extent. Political contributions. This was made effective even before 1st April 2014. Two things were made effective before 1st April. CSR and political contributions. Yeah, because it is useful to politicians. They can say that now you have to spend 2%, so you develop my area at your cost. Disclosures. This is more or less similar to 299, but there is a big problem in the drafting. You might have noticed it. Unlike section 299, this section does not cover interest of a director when director himself is a party to the contractor arrangement or his relative is a party to the contractor arrangement. And this is because of the wording in subsection 2 that contracts or arrangements with specified parties only will be covered. So that means if I am appointing a relative of a director, say to hold an office or place of profit, then section is not applicable. This is ridiculous. Interested director definition is given in section 2, but that definition has not been made applicable to this section. These are all drafting problems. And sorry to say, but definitely, and I think MCA should frankly admit this, that some drafting has been done by the people who have neither in-depth knowledge of company law nor legislative drafting skill. And this should have been avoided. This is very ridiculous. Another problem is, and this is going to create problem, this section, 299 was better. In 299, subsection 3, it was provided that if a director gives a general notice once in a year, giving the names of bodies, corporate and firms, then any contractor arrangement entered into by the company with those bodies, corporate and firms, director would be deemed to have disclosed his interest. No separate disclosure was required. And we have been doing it. Now separate special disclosure is required. There is a provision for giving notice in subsection 1, once in a year. But then similar provision has not been made. So that means if I give a notice that I am interested in a firm, because I am a partner or my wife is a partner, company when enters into contract with the firm, I will have to make a special disclosure again. And I do not know why this has happened. Actually 299 could have been copied word to word, maybe with some change. But they tried to do something different and created a mess. Now question is arising that whether a director should disclose his interest when a contract or arrangement is being made with the director himself or his relative, because section does not provide for that. How to go about it? My answer to that is that please do not do that. I mean, please don't avoid disclosure. Because going by the principle of fiduciary duties of directors, avoiding conflict of interest and duty, it is desirable, rather necessary, to make a disclosure when a contract or arrangement is being made between the company and the director or his relative. And record it in the minutes even if there is no specific requirement. It is in the interest of the directors. Now, it is also possible that some of the contracts or arrangements will not go before the board at all. We don't place every contract or arrangement in which director is interested before the board. But since the director is required to make a disclosure in each contract or arrangement entered into by the company with specified parties, the directors and company secretaries will have to be extra careful in future to ensure that all contracts are brought before the board, at least for the purpose of disclosure, not for approval. Now take an example. if you enter into a contract with a related party in which director is interested, and that contract is entered into by some officer of the company under the delegated power, through power of attorney. We delegate several powers to several people, and that contract is signed by him. It doesn't come before the board. But then now you will have to bring all those matters, at least periodically, before the board. Now, how companies are going to do, I have no answer at the moment, but we'll have to do this. Disclosure form is there. All these notices. Now you remember that all resolutions which are required to be passed under section 179, including noting of disclosure of interest by directors, are required to be filed with the registrar of companies now under the provision corresponding to 192. All these notices will be taken note of by the board at a board meeting, and that resolution is also required to be filed under equivalent provision. I think it is 114 or something. Yeah. Yeah, but you need not attach a copy of the disclosure. In my view, copy of the disclosure placed before the board need not be attached to the form which is being filed. You can just say that following resolution was passed, and that resolution will be just one line resolution. Actually, it doesn't require resolution as such, but now they are saying resolution. It is hereby resolved that the notice of disclosure given by the directors in form number so and so be and is hereby taken on record. That's all. I don't know. That I have no answer to that. Why these resolutions are required to be filed and what ROC is going to do with that. Okay, now we straight away go to loans. 185. Very controversial. Now some exemption has been given. Section is applicable to private companies also. So far they have not given total exemption to private companies. There is a power given to the central government under the new act to exempt any class or classes of companies from any provision of the act. I have strongly recommended to the MCA that under that provision, I think 468 or so, the government should issue a notification giving exemption to private limited companies from certain provisions, like 1956 Act. I do not know what is the philosophy, because 1956 Act was pro-exemption for private companies. Now it is anti-exemption. I do not know what the philosophy is, because you want growth, but you are putting so many restrictions that private companies' life will become miserable. This is one of them. In only one case, loans can be given to directors, that is, managing and whole-time directors for any purpose under the scheme of the company. If managing directors are not covered by the general scheme of loan, many companies have loan schemes for employees. If executive directors are not covered by that scheme, you can make a separate scheme, get a special resolution passed, give the loans for any purpose. Secondly, loans can be given by a company in the ordinary course of business. Now, before that, what is the interpretation of save as otherwise provided? It has created a lot of debate, because main argument of the people was this, that this section starts with save as otherwise provided, and otherwise is provided in 186. So if I cannot give a loan under 185 and guarantees and securities also, I can do that under 186. I do not agree with that. Because there is another principle of interpretation which in my opinion would apply, namely special provision overrides general provision. This is a special provision, 186 is a general provision. There is another rule of interpretation that you cannot interpret a statutory provision in such a way that it becomes a dead letter. If you say that I can give loans under 186, then 185 becomes a dead letter. Because under that you can give it to any person. Please remember, 186 is now allowing loans to be given to any person. Earlier it was only body corporate. So it is wide now. Company can give loans to anybody, including directors. But directors cannot be given loan under 185. No, I cannot excuse you. No, because I have to finish the presentation. There are quite an important provision. Yeah, but that means a loan which cannot be given under 185 can be given under 186. And all kinds of loans which are prohibited under 185 can be given under 186 now. That's what I said. Because of the change in wording. Every loan which is prohibited by 185 can be now given under 186. So that means 185 is gone, abolished. And I do not think court will accept it. Court will say that this is a special provision, that is a general provision. In other words, that provision is subject to this provision. Again, what is the meaning of subject to? All these expressions have been explained in that book. 1 minute. Now, the problem is, the second point is that exemption has been given to give loans, guarantees and securities by the companies in the ordinary course of business. Now, what is the meaning of ordinary course of business? For example, if this company owning this hotel wants to give loans to directors and other parties mentioned in the explanation, I'll come to that explanation. Who are the parties to whom loan is prohibited? Suppose this company wants to give a loan to those parties. Can you say that this company is giving loan in the ordinary course of business? Suppose there is a manufacturing company wanting to give loans to those parties. Can you say that it is in the ordinary course of business? Suppose there is an NBFC wanting to give loan. It has the permission to give loans. Can you say? Answer is yes. Can a banking company say that it is giving loans in the ordinary course of business? Answer is yes. Can infrastructure finance company, which is also an NBFC, wanting to give loans to those parties, say that we do it in the ordinary course of business? Answer is yes. So those companies which carry on the business of giving loans, guarantees or securities can do that bypassing this section. It's not applicable to them. So for example, a company called Shrey Infrastructure Finance Limited in Delhi, in Calcutta, 185 is not applicable to them. 186 is not applicable to them because they are in the business of giving loans. They have a license to give loans, but not other companies. Because again, the same principle of interpretation will apply. If you say that every company does giving of loans in the ordinary course of business, even if it is a manufacturing, trading or hotel company, then this provision will become redundant. So all these aspects will have to be kept in mind. Now, who are the parties to whom giving loans, guarantees, securities is prohibited? Director of the company, director of the holding company, partner of the director in a firm, relative of a director. Then firm in which director is a relative, private company. So if two companies have common directors, this section will apply, even if they are private company. And this is really creating a problem. And especially when a private company wants to create a new project, a new company, and fund it, you cannot do this. 295 at least allowed giving loans by government approval. Now this is completely prohibiting. And that is the problematic area. And I think MCA will have to look into it. They can't avoid it. And maybe now the new government, this matter might be taken with the new government and some solution will have to be. There may be good reasons, I don't doubt. But then this is creating a serious problem. Infrastructure businesses, construction businesses are severely affecting because I want to create a company to take up a new project or SPV for infrastructure activity, but I am not allowed to fund by way of loan. If that company wants to borrow money from a bank, bank will say give a guarantee. Parent company should give a guarantee, but I can't give it because this is coming. So that means I should not have common directors. And any of my directors should not be a shareholder in that company. Otherwise this will apply. So I think this will have to be looked into. No, that is different. Now under the rules they have allowed loans to be given by a company, wholly owned subsidiary, by a company to a wholly owned subsidiary subject to the condition, and also guarantees, in respect of guarantees they have stipulated a condition. That's fine, that is a different issue. Now the question is, can a loan given by a holding company to a non-wholly owned subsidiary, because wholly owned subsidiary is exempted, loan given to wholly owned subsidiary is exempted under the rules. But can a loan given by a holding company to non-wholly owned subsidiary be prohibited under the last clause? My answer is no. Many people say yes, my answer is no, because this is not a new provision. I don't know why there is a hue and cry about it. This was there in 295 since 1956. Previously also it was there. And it has been interpreted in several cases in the UK, because under the UK Companies Act, this is called a shadow director. There is a definition of shadow director in the UK Act 2006. And my interpretation on the basis of analysis of these cases is that only when two conditions are satisfied, even in the case of wholly owned subsidiary or non-wholly owned subsidiary, holding company to subsidiary company, only when two conditions are satisfied. Number one, there are instructions or directions continuously given by the holding company to the subsidiary company for the conduct of affairs of the subsidiary company. And number two, those instructions and directions are followed and acted upon by the board of the subsidiary. Unless there is evidence, there is no presumption. There is no presumption that the board of the subsidiary always acts according to the directions and instructions of the holding company. I have done an in-depth analysis of all these cases. In fact, I have sent an article to Charter Secretary, probably it will be published soon. If anybody is interested in having a copy of that paper, you can write to me, I will send it to you. But you take your own view. I am not giving you any legal advice in this program, because I am not charging you. But my interpretation is definitely that loans given by holding company to subsidiaries is not prohibited under the last clause. Yeah, all that I have discussed in that paper. Exemption, which you have mentioned, wholly owned subsidiary, and guarantees and securities subject to the condition. This is good, limited but good exemption. It was required. Yeah, that is another issue, but I have a solution to this problem also, if you recall what I said about 5 minutes back. And it is quite possible to take a view that this is an implied exemption. This is an implied exemption. I'll read out to you, this is a very important provision. 462. Power to exempt class or classes of companies from provisions of this Act. The central government may, in the public interest, by notification, direct that any provisions of this Act, underline these words, any provisions of this Act shall not apply to such class or classes of companies, or shall apply subject to certain conditions. And this is a new provision. It was not there in the 1956 Act. In the 1956 Act, there were specific exemption provisions like Section 25 companies. They had given a lot of exemptions, government companies. But now there is a general comprehensive provision. Now what happens under this provision is that, suppose tomorrow the government issues a notification. They say by notification, not circular. They issue a notification in the Gazette that private limited companies shall be exempted from following provisions. And they give a list of sections. That is valid because government has the power, subject to the condition that it should be published in the official Gazette. Now, this exemption in the rule has not been technically issued under Section 462. It has not been issued technically under 462, but it is possible in my view to take an interpretation that this is nothing but an implied exemption, and one major condition under that section has been fulfilled, Gazette notification. I think all of you are aware that Bombay High Court has given a judgment last week that those rules under the new Act which have not appeared in the official Gazette have not yet come into effect. And they have also struck down the SEBI's circular requiring scheme of compromise or arrangement to be approved by postal ballot. They say it is invalid because the section clearly says scheme should be approved at a meeting. You cannot override and say that it should be done by postal ballot. They have also discussed about e-voting, electronic voting, which has now been made compulsory for listed companies, and there are serious problems about it. Because they are saying electronic voting should be made available at the meeting, AGM. But in the rules they are saying it should be made available at the portal of the company for 3 days, means not at the meeting. Then whether electronic voting should be for show of hands or for poll. Some people will say that I want to use electronic voting. I will go to the portal and deliver my vote, cast my vote. They need not attend the meeting and vote at the meeting. and therefore it is quite likely that the meeting will become an empty formality. People will say that I don't want to cast vote, or I want to cast it electronically. So balance sheet, etc. will not be discussed at the meeting at all. So these are some of the problems, and one of them relating to court convened meetings under 391 has been dealt with by the Bombay High Court, and they are saying the same thing, that you cannot dispense with the meeting, at least so far as 391 is concerned. I don't know how this judgment will affect the postal ballot and e-voting matters under the New Companies Act, but let's not go into that. 186. That is also wholly owned subsidiary. Absolutely. That was so in the case of 372A also. And my view is that wholly owned subsidiary includes step down wholly owned subsidiary. Yeah, that is not expressly exempted under the rules, but according to my interpretation, this last clause will not apply. Therefore, unless clause C is applicable, there is no problem. 186, I don't think I need to discuss this because this is exactly a copy of 372A, except one change, two changes rather important. One is that loan can be given to any person, and second change is that wholly owned subsidiaries, investments, loans, guarantees and securities have been withdrawn. But now, under the rules, it is allowed. Yeah, of course. Every investment, loan, guarantee and security under section 186, like 372A, requires board's unanimous approval. That you have to tell MCA. %60% or 100% limit. In excess of that, you need to go to the shareholders. I think we'll have, if possible, question answer session. Related party transactions. So we have to close at what time? 1 o'clock? Sorry? Yeah. All provisions of 186 must be complied with in respect of all loans, even if those loans are covered by 185. Obviously, because these are two independent sections, both have to be complied with independently. And that's why I am saying that if you can give a loan under 186, you cannot say that I'll give it without complying with 185. It's very difficult to justify. Sorry? Yeah. And this may create a problem for debentures also. (297) and 314 have been combined in 188. These are the transactions wider than 297. It is much wider than 297. Office or place of profit also covered. Definition of office or place of profit is the same as in 314. There is no change. there must be a contract or arrangement. Out of these 7 categories which I have mentioned earlier, and contract must be with a related party as defined. This related party definition also I have broken down into separate items, and I think it is coming to 28 categories, because 4 categories are covered by the rules, remaining by the Act. So total 28. If anybody is interested in having a copy, you can write to me by email. You know, sometimes we emotionally or otherwise, like abundant precaution, unnecessarily try to rewrite the statute. Recently one person asked me, there is a managing director, his wife has a car owned by her. She has given the car to the managing director on lease, maybe for tax purposes. Company is giving the managing director allowance for the purpose of commutation. And managing director is paying lease rent to the wife because car is owned by her. There is no contract between the wife of the managing director and the company. This section says that there should be a contract between the related party and the company. This is not a contract between the company and related party. So he was asking me whether 188 is applicable. So I said, why you say that? Because wife is not a party. No, bola, abundant precaution. I said, then you can do anything by abundant precaution, but you are rewriting the statute, which you are not allowed to do. Only Parliament can do that. So we have to ensure avoiding wrong advice given to the management by applying certain rules which are not the accepted rules of interpretation. And therefore I am emphasizing everywhere in all seminars that we should learn, we should become skilled in the interpretational rules. Here it is very strict, and the definition of related party is an exhaustive definition. When a definition uses the word means, it is an exhaustive definition. When a definition uses the word includes, it is not an exhaustive definition but expansive definition. This difference should also be understood. Related party means only those parties which are mentioned in the definition. You cannot bring in a third party and say that this is also related party because that party is related to the managing director. But there is no contract or arrangement between the company and the related party. So this is a very important aspect you should keep in mind. Let me complete first. This is also important. Don't unnecessarily bring the old contracts before the board for approval. The words used in the section are, no company shall enter into a contract or arrangement. What is the meaning of enter into? When you enter into a fresh contract, if it is with a related party and if it is one of the 7 kinds of transactions, only that should go before the board. Now please remember, there is some misunderstanding about the first point, first criteria. Company having a paid up share capital of the prescribed amount, they have prescribed 10 crores. What does it mean? It means that in the case of a company having a capital of 10 crores or more, every contract, regardless of the value, every contract or arrangement, regardless of the value, or money payable under the contract, should go before the board, before the shareholders. However, if the company has less than 10 crore capital, but it falls under 188, then only those contracts or arrangements which are of the prescribed value under the second criteria will have to be placed before the shareholders. This should be clearly understood. For example, the limit for office or place of profit under this provision is 2,50,000 per month. Now, if a company wants to appoint a related party to hold an office or place of profit, and if the company's capital is less than 10 crores, then this section will not apply, because the remuneration payable is 2,50,000 per month. But in the case of a company having more than 10 crore capital, 10 crore or more, all contracts will have to be approved. This is a very important and somewhat irritating provision, but then there are solutions. So this is what I said. Now, can you pass a general special resolution giving authority to the board to enter into contracts with any related party? General authority, not specific contract. We have been doing it in certain cases. General authority is given to the board to do certain things, like 293(1)(d) or even 81(1)(a). Can that type of resolution giving general authority to the board to enter into contracts with related parties from time to time of any of the kinds mentioned below, that means those 7 categories given in subsection 1, can such resolution be passed so that you need not go to the shareholders repeatedly whenever there is an occasion to enter into related party contract? My answer is yes, it can be done, because it is not prohibited. And even by implication also, it is not required that for every specific contract there should be shareholders' approval. This is again a problem. No, I don't go by the idea. Wait. We'll have question answers at the end. I do not go by the idea behind the provision. Supreme Court says that what was the idea behind the statutory provision is irrelevant. What was in the mind of those who drafted is not relevant. What was in the mind of the minister, what minister said in the parliament, are all irrelevant. Statutory provisions must be interpreted only on the basis of the language of the provision. That's why I am emphasizing no emotions, no spirit. Sometimes people say, go by the spirit of the provision. I say, where is the spirit? Show me where the spirit is. Where to find? To find in the parliamentary debate? in the committee's report, in the minister's speech, in the MCA clarification, where? There is no question of spirit. Like, the courts say, principle of equity is not applicable in interpreting a statute. Similarly. So in my opinion, since it is not, see the language difference. If you go to the 372A section, investments, loans, guarantees, securities in excess of 60% or 100%. The section was very specific that there should be specific resolution for each transaction and certain disclosure should be made in the resolution. No such provision has been made here. So it is quite possible. Anyway, we go to now the most important aspect of this section and close the discussion on this section. What is ordinary course of business and arm's length? For example, you are appointing a son or daughter of a director to hold an office or place of profit at a salary of say 5 lakhs rupees per month. That person is qualified in the particular area, appropriate experience, company needs the services in that position. If company had not appointed the son or daughter, it would have appointed some outside person on the same terms and conditions, same salary, considering the age, experience and qualification. My nomination committee examines this aspect, gives a report that this is a transaction at arm's length, as if it was made with a non-related party. The definition of arm's length is the same. Arm's length transaction is a transaction if it was made by the company on the same terms with an unrelated party. So I said that yes, my HR department has done some groundwork, collected the information, nomination committee has given a report that only because that person is the son or daughter of the director, it cannot disqualify because that person had all the qualities and job requirements which any other person would have to satisfy. Is it not a transaction in the ordinary course of business? I would say it is a transaction in the ordinary course of business because I need the services of the person for my business and I am satisfying the condition of arm's length. Suppose you are paying a royalty to a parent company which is a related party. Say Japanese company, you are paying royalty. Is it not in the ordinary course of business? It is in the ordinary course of business. Because I carry on the business of manufacture of certain products for which I entered into an agreement and I pay royalty. Suppose you sell goods or buy goods, say raw material you purchase from a private limited company in which director is a shareholder, related party. But I am buying the goods without extra commercial considerations, purely on the basis of market rate and the terms and conditions similarly applicable to others. No discrimination, no extra commercial consideration. Is it not in the ordinary course of business at arm's length? Yes, it is. And you can, suppose I take on a lease an office premises to be used by my company for the purposes of my business, office premises. From whom I take it is a related party. But I get the valuation done. I pay the rate according to the market rate. I have a valuation report. I have a data collected from various estate agents, etc., etc. And I come to the conclusion that if I had entered into this transaction with an independent party, I would have entered into on the same terms. Is it not in the ordinary course of business? Answer is yes. So, most of the transactions which company normally enters into or does in connection with or for the purposes of the business of the company can be called transactions in the ordinary course of business. The only important aspect is arm's length. And for that you have the sources available to establish that the terms are at arm's length. And in respect of transfer pricing regulations, we have the data available in certain cases. So in my opinion, many of the transactions which otherwise fall under 188 can go out of 188, and if a transaction is eligible for exemption under the third proviso, there is a total exemption. Wait. Nothing is required to be complied with about 188. Nothing. Because there is also interpretation of this phrase, nothing in this section shall apply. There is a very classic Supreme Court judgment on this. What is the meaning of nothing in this section shall apply? But that also you have to read in that book. This is a brief explanation about arm's length. In fact, recently Supreme Court interpreted the meaning of the word transaction, and it was incidentally in that case, famous case, whether Comptroller and Auditor General CAG can audit telecom companies' accounts. And Supreme Court said yes. In that, there is a paragraph about the meaning of transaction. What is transaction? So, it is possible to take benefit of this exemption in majority of the cases. We go to the last chapter. Try to finish it in the next 15 minutes. Disqualifications. There is one important disqualification, that is age. Not below 21, not over 70, but over 70 is possible by special resolution. And then it is unlimited. That person can go up to 100 years of age, or even beyond that. Appointment must be made by the board, not by shareholders, but the shareholders' approval is required. Return to be filed. Schedule 5. There is not much difference between Schedule 13 and Schedule 5. In fact, Part 1 is exactly the copy of Schedule 13. Remuneration. Yes, 196 section will apply to private companies. 196 section will apply to private companies, that is regarding appointment, like 269. But 197 will not apply to private companies. Remuneration. So private companies are free to pay any remuneration to their directors, like under 1956 Act.
Schedule 5 will not apply to
No, no, not at all. Not at all. Not only in respect of executive directors, even in respect of remuneration of non-executive directors, these provisions will not apply. Yeah, but that's not very important. New definition of remuneration. There is a slight change in the definition. No, I won't say slight. There is a big change. One good thing is that perquisites now can be valued according to the Income Tax Act and the rules, which was not permissible under 1956 Act. 1956 Act required valuation of perquisites on cost basis. Now it is income tax. This is my interpretation of this definition. Managing and whole-time directors' remuneration in public companies. Overall limit 11%. You can pay more than 11%, but with the approval of the government. Net profit, same provision like 349. Mode of calculation. Fees for attending board meetings outside the purview of 11%. Inadequacy of profit or loss. %5 for one. 10% for two or more. If the limit applicable to your company is 10%, you can pay more than 5% to one and the remaining to the other. Suppose you have two managing directors. Limit is 10%. You can pay 9% to one and 1% to the other. This is also possible. I think I have said nothing is applicable to private company. 197 section will not apply to private companies. Consequently, Schedule 5 also will not apply. No, you meet me during lunch break. Please let me complete. No further questions. This is clear. There is some problem in the drafting, but it is clear by reading the two sections and interpreting them harmoniously that you will require shareholders' approval. Schedule 5, you have to follow part 2, when company has a loss or inadequate profit. I think all of us are clear about what is inadequate profit. Suppose 5% of your net profit is 10 lakhs and the remuneration decided by the board is 12 lakhs to be paid to managing director. This is a case of inadequate profit. Please remember, inadequacy of profit will have to be decided on the basis of the current financial year's profit and loss account and not the previous. So there is a problem that you go on paying, then at the end of the year you find that there is inadequate profit or even loss, then what is the solution? Solution is either recover the amount or go to the central government. Both have problems. Because recovery is a very difficult thing. First, company secretary would not dare telling the managing director, sir, you have to refund money. Then he will ask you, why didn't you tell me earlier? I have spent all my money now. So please remember, the only solution is to be careful with regard to the profitability level and comparable remuneration. I mean corresponding remuneration, 5% or 10%. And now we have the financial results available on quarterly basis. So you normally come to know what is the level of profitability and whether there will be a situation of inadequate profit or loss. And then if you monitor it properly and find out that there is going to be a problem because it is declining, profit is declining, then you better caution the management, I mean the managing director, and take the matter to the board for appropriate decision. And the only two solutions are going to the government or recovering. There is no third solution. So that will have to be done carefully when particularly profitability is declining. Now we go to non-executive directors' remuneration. They have removed the requirement of special resolution to be passed every 5 years. There is no requirement of special resolution every 5 years for commission up to 1% or 3%. It requires now only shareholders' ordinary resolution. You meet me during lunch break. Now there is one very important development which has to be noticed carefully. Under section 309, companies were not allowed to pay their non-executive directors monthly remuneration without the government approval. You could pay only commission up to 1% at the end of the year when profit and loss account is available. And 5 years validity special resolution. Now, you can pay your non-executive directors remuneration on monthly basis, subject to 1% limit, 1% or 3%. For example, in the case of a highly profitable companies, if board decides that non-executive directors should be paid remuneration up to 1% of net profit and 1% comes to say 10 crores, and you know that you have ample profitability, you can pay out of this 10 crore kitty 5 crores by monthly payment, 5 crores at the end of the year, or even 8 crores, 9 crores monthly, 1 crore remaining at the end of the year when profit and loss account is available. This is now possible because of subsection 6. And it uses the word director, not managing or whole-time director. Don't add the words. You are not allowed to do that. So a director can be paid monthly remuneration, but subject to 1% limit. So for some companies have already taken resolutions. I know about that. They will pay monthly payment to non-executive directors up to a certain amount. And remaining amount or more amount, they will pay at the end of the year, after the accounts are approved. So this point is to be carefully noted. Professional services. This is possible now without going to the government for opinion. So these are some important developments in the area of directors' remuneration. Now we go to KMP. There are some issues about it. In my view, one KMP can act in only one company, even if he has a dual qualification. Secondly, there should be an independent person for each KMP category. One person having CACS qualification cannot act as CFO as well as company secretary in the same company. There should be independent persons. If you have a managing director will be KMP. CEO, then CEO can be KMP. Manager can be KMP. But if you have no managing director, CEO or manager, of course, manager and managing director cannot be there at the same time. So if you have no CEO and no managing director, there should be whole-time director. If you have 10 whole-time directors, in my view, only one of them can be designated as KMP, not all. Sorry? No, even MD. MD is allowed to work in 2 companies, but KMP in only one company, except subsidiaries. Subsidiaries permitted in the case of CFO as well as CS. Only one person can be designated as KMP because there is no requirement that automatically all will be treated as KMP. Because KMP has to be appointed by the board specifically. And therefore board can decide that if we have 2 managing directors or 2 whole-time directors, who will be KMP out of them? And then you file the form giving the name of that person. CFO and CS independent person except in the case of subsidiary. No, if you have whole-time directors only, no managing director, then one of the whole-time directors will be KMP. No, you don't talk, let him talk. All whole-time directors KMP? No need. I have already clarified that if you have 10 whole-time directors, then you can choose one of them. No, I don't think that. No. So I think these are all important provisions of KMP. I don't think there is anything else to be discussed. Now the only one point is that if today, after 1st April 2014, you want to implement this provision, how would you implement? My solution is that there is no need for appointment as such. No fresh appointment. Suppose you have a company secretary, managing director, CFO. If you have not designated that person as CFO, but he is chief of finance, you want to designate him as CFO. You just pass a simple resolution that for the purposes of section 203 of the Companies Act 2013, Mr. So and so or whatever shall be the key managerial person of the company in the category of CFO or company secretary, or because there are 3 categories. So you decide who in what category, pass a resolution and file it, because return is required to be filed. That's all. In that resolution you add one more sentence in that resolution you add one more sentence that the terms and conditions of appointment of this person, of the managing director, as approved by the board in so and so meeting shall remain unchanged. Because that section requires not only appointment but terms and conditions also to be approved by the board. So at the moment this is enough. When there is a change, tomorrow somebody else is appointed in place of one person, then you have to pass a fresh resolution at a board meeting. CFO and CS. Why? Don't say terms and conditions approved by the board. Say that the terms and conditions as set out in his appointment letter, dated so and so, shall remain unchanged. Yeah, form is again a separate formality. My point is about whether a fresh resolution for appointment, I don't think so. Because you already have them, terms and conditions are already in place. You just want to designate that person now as KMP because the law requires it. Terms and conditions will not be, because you need not terminate the appointment and make a fresh appointment. That is not contemplated. I don't think there is any language in the section which requires this. Sorry? No, the same remuneration he will continue to draw. See, if you are changing the terms and conditions or remuneration, then you will have to go to the board. If you are not changing, like CS or MD, no change, they will continue. You don't need to pass a resolution for appointment. Yes. No. Managing director of one company is allowed to be a managing director of another company. Only two. Earlier it was more than two. Now only two. But he can be KMP in only one company. Then it is not a problem. But you will not call him KMP there. Now, with this, I have to wind up this session because there are only two provisions now required to be discussed, remaining to be discussed, and one of them is secretarial audit. So, I thank NIRC for giving me this opportunity, and I thank all of you for patient hearing.